Hello, good afternoon everybody. Can you hear me? I promised that this will be a 15-minute talk. So I have here my timer. 15 minutes lang to. Because, truth be told, I do specialize in intellectual property law. And this seminar talk is really more about taxation. And I suppose I'm just serving as the appetizer for the main course, which will be delivered by my distinguished co-panelists later on. I will also look forward to hearing some of your questions, and to the extent I can answer them correctly later on at the end of the talks. Here's my outline. I want to cover 4 topics, essentially. I don't know how novel these topics are to you. I hope at the end of my talk you will come away with something out of these 4 topics. The first topic I have is the concept of idea and expression dichotomy in intellectual property law. This is a concept in copyright. What is it? Essentially, sometimes some of my clients come to me, they say, "Attorney, do I have intellectual property protection for my outline, for my this idea I have?" Or it's very common. No? They come to me, they ask me, do they have protection? And then I like to tell them about this idea expression dichotomy, which you see before you behind. Essentially, between the idea and the expression, there is a whole series of things happening. And my example here is the making of a film. No? You have the idea, and then there's the concept, there's the story treatment, the storyboard, then you have the script, you have the filming, all leading up to the expression, ultimately, which is the film or the video. My proposal really is that the closer you are to the left, the less protected you are under copyright law. The closer you are to the right, then you are more protectable because you go into expression. Okay, as artists and creatives, you are very well versed in expression. It's very important right nowadays, the freedom of expression. All right. Under the IP code, it's specified that concepts, ideas, they're not given any protection. Same treatment as news of the day, facts, the words and the text of statutes and laws. There's no copyright for these things. These are in the public domain. There is a case decided by the Supreme Court entitled Joaquin versus Drilon, where we take this idea expression dichotomy to heart. It is discussed there. What is this? I don't know if any of you were alive back in the 70s. There was a dating show called Rhoda and Me. Now you're all familiar with these dating shows. There is a searcher, a lady who sits in front here, and behind the screen there's a wall. Behind that there are 3 gentlemen. She asks them questions, and based on their answers, one of them earns the right to date her. Okay? That was Rhoda and Me. Unfortunately, back then there was another dating show called It's a Date. And so the BJ Productions sued the manager of It's a Date on the ground that the show had the same style and format as their show. What did the Supreme Court rule? No copyright infringement. Why? Because apart from the manner in which it is actually expressed, the idea of a dating game show, the mechanics, the format, is non-copyrightable material. You don't possess copyright over that. So ideas, concepts, formats, they do not fall within the class of works that are susceptible to copyright protection, registration, protection dapat yan. So what is covered really by Because in this case, the show, rather than we had certificates of copyright registration, they registered it. The board ruled that what does copyright extend over? It extends to the individual shows of the show. So if you say you had 9 shows, one show, that's where your copyright extends to. Okay? You are expressing what is really a concept or a format in the intangible medium, which is the show itself. I think this was last year or 2 years ago, there was a major some noise about the Fernando Cancho's Uplift. People got riled up because his sculpture, which portrays a woman levitating, whose weightlessness is supported, whose weight is supported by her hair. It turns out that there are a couple of those sculptures in the Netherlands. So it raised the question, is this copyright infringement? Is this plagiarism? Is this sincere form of flattery? Perhaps for me, sometimes artists unconsciously or do not have the intent to copy. They might be influenced by something they saw. So it's really impossible sometimes. Of course, I'm not discounting the fact that there are copycats, and more about that later. So here you see a clear example. What do you believe this is plagiarism or copyright infringement? How many say yes? 1. How many say no? 1, 2, 3. If you ask me, if you look at the statues, first of all, you will see marked differences. Okay? What is coming through here for me is the concept of a levitating woman who projects a sense of weightlessness, rising up from the ground, supported by her hair. So I think it's more of a concept that is to illustrate. For centuries, painters have been painting the Madonna and Child, Virgin Mary holding the child. That's the concept. And you have Filipino artists who are doing that. They have it's a mother and a child. It's a very common concept. But the way you express that is the subject of copyright. Okay. Some basics on copyright. I don't think I need to let you know that it refers to literary and artistic works. There is works are protected by mere fact of creation. There is no need to register anything with whatever office. However, for me as a lawyer, if you want to register, let's say, the manuscript of your book or a copy of your film, you can do so with the IPO and with the National Library. It makes my work easier to prove in court that indeed, as of this date, there is copyright to this film, this book, this painting, manuscript, whatever. If we should go to litigation, there's this piece of paper that says the deposit period, so it's existing at that time. Okay? Now, who owns the copyright? In general, it's the creator. In works of joint authorship, let's say there's a collaboration, it's joint. So sometimes you need to set the parameters for that. Who owns the copyright for work during the course of an employment? I encountered this many times in the creative arts, creative agencies, ad agencies. Number 1, if it's the employee, if the employee creates the work, but it's not part of his regularly assigned duties, it belongs to him, even if he used the time and facilities of his employer. But it belongs to the employer if he does the work in the course of his regularly assigned duties, unless there is an express or implied agreement to the contrary. For commissioned work, it's very important to note that there must be a written agreement about the commission. Otherwise, if there is no written agreement, let's say you commission somebody to paint your portrait, the painter or the artist owns the copyright and he owns certain economic rights to that, but you own the material object. For films, it's these 5 people. If there is no agreement, Copyright exists from the moment of creation, and we get that from the Berne Convention. This is the Berne Convention provides for the automatic protection of your work. And what is important to note also with the Berne Convention is that reciprocity is provided. So those signatories, the countries and nation states that are signatory to the Berne Convention must extend reciprocal protection to works created by other nation states who are signatories to the same convention. For example, if we create a work here in the United States, it must be given the same amount of protection as they extend to their nationals. So it doesn't matter. It's like if you think about it, it's like an international protection for artists because of the Berne Convention. Duration of copyright in general is 50 years from the death of the author. So during the lifetime of the author or creator, plus 50 years here in the Philippines. In the United States, I think it is 70. Just note that for films, videos, and photographic works, film and photos, there's a different duration. Why do I make mention of this? It's because to tell you that at a certain time, the work will go to the public domain, which is important for the advancement of arts. If you ask me, I think 50 years is too long. With the way things are moving now, it's moving so fast, I think more work should revert to the public domain at a faster rate, because we are moving away from the previous intellectual property regime. Okay, economic rights of copyright, reproduction, adaptation, first public distribution, 1, 2, and 3. Number 4 is the rental of, this refers to movies and software programs. Number 5, public display of the original. This refers to what you're seeing here, how the work is being displayed. 6, public performance of the work. And 7, the other communication to the public of the work. Number 7 refers to distribution of artwork and literary creations and artistic creations over the internet. So number 7, very important also. Aside from the economic rights, you have moral rights of the author. Basically, you can divide it into 2. The right of attribution, which you see number 1. Number 1 is you have the right that you will be attributed as the author or creator of this work, no matter where, let's say, it is published or displayed, you must be acknowledged as the creator. Second right is integrity, the integrity of the work. The author, for example, in number 2, has the right to make any alterations of his work prior to or even to withhold it from publication. Number 3, which is important for artists and creatives, you have the right to object to any distortion or mutilation or modification of your work which would be prejudicial to your honor and reputation. And number 4 is to restrain the use of your name with respect to a work that is not of your own creation or in a distorted version of your work. Okay, I have 1.5 minutes left, but I have 2 more topics. Fair use, very important, very interesting. Most fair use falls into 2 categories. Fair use is used to comment upon or to parody certain issues that you feel are important. You admit you're copying something, but you're raising the defense of fair use. Section 185 is fair use. The fair use of a copyrighted work for criticism, comment, use reporting, teaching, and is not an infringement of copyright. Okay? So I'll skip these 4 factors. Just know that the courts generally look at 4 factors plus others in determining whether or not there is fair use. Okay? Is this fair use? On the left, a photograph taken by a photographer. On the right, the use by an artist named Shepard Fairey to create an iconic poster used by President Obama during the United States election. Is this fair use? How many say yes? How many say no? Unfortunately, we won't know. There was a civil litigation about this, but let me just finish this. We will not know. We will not know because the case was settled out of court. Last topic. Just going to overtime. Art forgery, counterfeit art. One of the pet peeves. Here you have the work of a well-known national artist. Okay. Here you go. There. Familiar to you all. 2012, I was walking in Greenbelt. I saw this exhibition, and literally, I could smell fresh paint coming off from the canvas. And it was an exhibition of his work, newly discovered, with certificates of authenticity. But certain doubts were raised by both art critics and art lovers alike. Why? These works, there is a different technique used and different canvas used. So, but for me, it didn't need any explaining. I walked by, I could smell fresh paint. So this cannot be H.R. Ocampo paintings painted in the 60s or 70s. Forgery is punished under Republic Act 9105. And basically the problem in enforcing the law, there is no art authentication panel that is being convened by the National Museum Board of Trustees. So if there are cases of forgery, they have to convene an art authentication panel whose duty it is to determine whether a work or a painting or sculpture or whatever is indeed made by the creator or by the artist. Otherwise, if they can certify that it is fake, they can recommend prosecution. Okay? And if you don't have this, which is a prerequisite, you cannot prosecute people for forgery. Okay, these are the penalties. This is my outline. I hope there was some takeaway from there. I'm just about 3 minutes over time. Thank you for listening.
Thanks very much for that. That was very Robert BJ Palatao talked to us a little bit about registering your businesses or yourselves.
Good afternoon, ladies and gentlemen. I'm here to discuss basically what will, if you are engaged in the business of art, if you are part of the art industry, we will be discussing what steps you should take in order to make your business or your livelihood legitimate by registering your business. So, the first thing that you have to do in order to determine whether you are in the art business is, number one, are you creating an artwork or artworks for the purpose of selling these works? Number two, are you engaged in the selling of artworks? And number three, are you engaged in the buying of these works? Now, notice that these three questions actually pertain to the three major players in the art industry. So these are other different relationships between the people involved. Number one, when there is an artist who is being commissioned by a buyer for the creation of a work of art. Number two, the artist-dealer relationship. And number three, the auction houses. Now, what is an artist commission? It is actually a formal arrangement for someone to do a piece of work for you. So if you are an artist, This is when a buyer commissions you to perform a work or to create a work within the specifications provided by the buyer. Okay? Now, what are the common themes of commission agreements? Number one, there should be an agreed upon drawing or committing the artist to the subject matter. You know, you don't usually commission, when you do commission works, a certain creativity process comes to play. And usually, the buyer has a say to what kind of work will come up. It is seldom that you will ask an artist to create something that is not what you envisioned it to be. So there is a certain artistic contribution on the side of the buyer. Number two, it is important to note when you make these kinds of arrangements, there should always be a terms of payment. Of course, since you are doing a specific job for another person, there should be an agreed terms of payment or an agreed price or compensation. And number three, it is important that when you make these kinds of agreements, there should be a specific delivery date. It might not be a specific date, but it should be at least a reasonable period in which an artist will be able to make the work for you. And finally, you must specify what kind of materials will be used in creating this work. Now, what are the problems that are being encountered when it comes to commission works? So number one of the problems is client satisfaction. Since you yourself, if you are the buyer, since you yourself were part of the creative process, you envision a certain product that you aspire to be. And one of the problems is that when the artist is not able to deliver what kind or the quality of product that you wanted the artwork to come up with. So this becomes a problem between the artist and the buyer because they cannot agree as to the quality of work. So what do you do now in order for you to be able to avoid these kinds of problems? One of the things that you should agree upon also when you make these works is that you should specify which kind of satisfaction or whose perspective should be followed when you are asking for satisfaction. So number one here is client satisfaction, meaning the client is the sole judge as to the quality of work that will be produced by the artist. So if the client here decides that the quality of work that was delivered to him is inadequate, then he can completely reject the work that was delivered to him. However, in case the artist agrees that it is to the artist's satisfaction, then it is the artist who will determine the quality of work that will be given to the client. Okay. Sorry. Okay. Number two, the second kind of relationship that artists usually have is between an artist and a dealer. Why? Because a dealer is considered as a person who is primarily engaged in the buying and selling of works. Now, an artist doesn't have, the first example earlier was an artist was commissioned by a client. This time around, it is not the dealer might not be the end user or the end buyer of this product. It is possible that a dealer has the eye for looking at great artworks, and he has the ability also to sell and make money off the works of an artist. So this is the second kind of relationship that is involved in art industry. Now, again, a dealer is a person who is primarily engaged in the business of selling works of art. No, there is no government license required for dealers to engage in this kind of business. However, the relationship between the buyer, the dealer, and the artist is one of a special kind of a relationship. Why? Because dealers in general, they have a certain clientele that has a certain taste. So this means that the artist must be able to satisfy the qualifications or the desires of these buyers. So what happens now is that the dealer should be able to direct or give some sort of direction to the artist so that he will be able to produce works that are saleable, so that he can make money off it. Now, what is the special kind of relationship that a dealer has with his artist? It is one of, it is called fiduciary relationship. Why? Because usually the dealer, whenever he buys or he obtains the artwork created by the artist, there are two ways of acquiring. Number one, it can be through a direct sale, meaning the dealer will buy the property, the artwork from the artist. Okay? In that case, the ownership of the work now transfers from the artist to the dealer. Ibig sabihin, wala na pong say yung artist dun kung kanino ibebenta yung work. However, most cases, dealers only artists usually just consign these works to dealers. Meaning the work is still owned by the artist. Okay? And the dealer now acts as an agent for this artist. Now, in a contract of agency, it is required that the dealer who acts in behalf of the artist, of course, gives him. First, the dealer now has certain responsibilities, which is a higher form of responsibility towards the artist. Number one, the dealer is required to care for and manage the consigned property. So when an artist delivers the property to a dealer, considering that the dealer is still not yet the owner of this property, the dealer in turn should, even though he doesn't own the artwork, he has the responsibility of taking care of the artwork. Number two, he must deal fairly and honestly when dealing the artwork. Why? Because at the end of the day, the primary interest should be for the benefit of the artist and not of the dealer. Okay? So when you say fiduciary relationship, you cannot put yourself first before the artist. At the end of the day, it should be the artist's rights which should be protected. Okay? So in order for you to avoid any kind of conflict of interest, the question would always be, would this benefit me more or would this benefit the artist more? Okay? And the answer should always be, it should always be for the benefit of the artist. Okay? Now, what are the problems encountered here in the Philippines, not just in the Philippines, but everywhere around the world? What are the common problems between a dealer and an artist? One of the problems that we encounter is that because of lack of contracts. For some weird reason, I have several artist clients, and I have a client who deals with artwork. They're here actually. The staff are here. But I've always told them that we have to encourage using contracts. Most artists are scared of contracts. I don't know, they really don't want to discuss these things. Written contracts. They only want to discuss it verbally, maybe a handshake, and that's it. Now, the problem with the lack of written contracts is, and the dependency on oral contracts, is that, of course, art is already vague. There's already, the definition itself is almost impossible. So the probability of you not being able to agree on certain matters is a problem. So the best way for you to avoid these issues, delivery date, as to how much, as to the quality of work, as to the materials used, if you will have, so that you will be able to avoid these discussions or these awkward discussions later on, please write it down. It's as simple as writing it down, okay? And having it signed. A contract doesn't have to have a special form, okay? It just needs to be at least written. In this part, in this case, it needs to be written and it must be clear as to what you are agreeing. Now, what are the common terms in an artist-dealer agreement? Number one, it's usually, sabi ko earlier, no, there are two kinds. The first kind is a direct sale, meaning the dealer is the one buying the property or the artwork from the artist. The second kind, which is the most common kind, is when an artist consigns his work to a dealer. So, there must be a term there that says that an artist entrusts his work to the dealer for sale. Meaning, he does not transferring ownership of that property or that artwork to the dealer. And instead, the dealer is just holding it in trust for him to sell the artwork. Number two, when you consign a work, make sure that you specify what work you are depositing or what work you are entrusting to this dealer. And number three, of course, there is usually a duration as to how long this dealer will hold on to the work. Because once you entrust it to him, of course the dealer will promote it, he will invite people to come and look at it, and that entails expenses. Unfortunately, if he is not able to sell it, there must be a definite period as to when you will be able to get the work back. Because if he already spent money on promoting it, he can easily argue, no, wait, I haven't gotten any return from the service that I provided you. So there begins the conflict between the artist and the dealer. So it is important that you specify the duration in which the dealer may hold on or may sell your artwork. But as a rule of thumb, dealers are also what we call sometimes as art advisors. What they do is they usually direct or advise the artist as to what works will be produced so that it will be easier for them to sell. And of course, the dealer will also make exhibits or promote these works for you so that it can be sold. And as a rule of thumb, whenever you consign a work, it's usually displayed in at least 2 exhibits, or the artist must have at least 2 exhibits per contract with the dealer. Number 3, it should also be clear as to how much is the commission. It should be clear. The standard here in the Philippines is that galleries get like 50%. But this is just the standard. Again, it is a business. You have to understand that galleries, they also need to make money, artists need to make money. So there is always room to negotiate as to how much the commission should be. So don't be afraid to discuss or to negotiate as to how much the commission the artist will, the dealer will get from the sale of the artwork. And number 3, this is actually one of the most important terms that needs to be in the contract, is the ownership of the intellectual property rights. As Attorney Bengson discussed earlier, when you create works, there are certain rights that are created. And these rights, particularly the economic rights, are assignable to other people. So it is important that the owner or the creator agrees to who owns these intellectual property rights. Number 3, options. Well, as we discussed earlier, there are 3 people: the creator, the artist, the dealer, and the buyer. These are the three main people. Now, in auctions, basically these three are just in play at the same time. The artist will consign the work to the auction house, and the auction house will be the one to sell it to the market. So, what's next?
Most detailed parts of this afternoon, but I'm sure you can make it understandable.
Okay, good afternoon. Just make this simple for you. Hopefully you'll be able to understand the question. Then this afternoon. Basically, before going to the BIR and registering your business, you have to have a business permit. If you're a corporation, you need to get a business permit. Once you have the business permit, then you go to the BIR and register your business. In registering your business, it's like what was told to you a while ago. You have to register your business. You register your business in the district where your business is located. Let's say here in Makati, there are 4 districts: the north, east, west, south BIR offices. So if you're here in Legazpi Village, you should register yourself with RDO 49. Because if you register in another district, the BIR will not recognize your registration, and all the tax payments that you made in that district will be considered off-site, and you will be assessed penalties. So it's important that when you have a business, you get an accountant who will do the registration for you, so that you will be able to register in the right district and pay the corresponding taxes within the right district. Because in Makati is divided into 4 districts, and if you are here in Legazpi Village, you should pay your taxes in any bank within Legazpi Village. Because if you pay your taxes in Salcedo Village, the BIR office in Legazpi will not recognize it, and they will impose penalties for late payment of taxes. Okay? That's for the business side. If you are a dealer, if you have your own office and then you're selling paintings, that's what you do. You register your business. Now, for artists who doesn't have a business, but they want to sell their artwork, what they should do is first, they should get a tin. And to get a tin, the President of the Philippines made it easier for individuals to get a tin. Right now, you just have to go to the district where you are living and present any government-issued ID. If you don't have any government-issued ID, such as driver's license or passports, you just have to present your birth certificate. Or if you don't have any birth certificate, you just have to execute, you just have to go to your barangay and ask for certification from that barangay informing the BIR that you are a resident of that district. And with that certification, you can now get a tin. And once you have a tin, then you can start working and selling your artwork. Okay. When you sell your artwork, it means that you're earning from it. And once you earn from it, you should be registered with the BIR. And the income that you will receive from such sale should be reported to the BIR. It's a bit tricky with regard to how you report it, because there are monthly reportings, and there are quarterly reportings, and there are annual reportings. I don't think you will be able to absorb everything, but it's better that you get an accountant who will do all these things for you. Lawyers like us, we get an accountant who will do these things for us, because once you pay make a payment of what is due for that particular month, there will be a corresponding penalty that will be imposed. Okay? During the art in the park, I was also invited to give a talk with regard to registering your business, most especially for artists. Because artists would tend to just sell their artwork and not, as much as possible, if they can get away with it, they will not report their income anymore. But as a citizen of the Philippines, any income realized here in the Philippines is taxable by the government, by the BIR. So I am encouraging the artists to register, get a name, get a business permit, and then get an accountant who will take care of their filings so that they will be contributing to the Philippine government in terms of raising revenue. Because as citizens of the Philippines, we are also benefiting from the infrastructures being undertaken by the government to make our lives comfortable. That would be my thought here about requiring artists who do business to register with the BIR. That's all.
Thanks very much. We can now take questions from the audience. I'm sure you have a lot. They covered a lot.
Hello. Yeah, I have a question around IP and ownership. Do you happen to know what types of rules or regulations would apply? Say, two artists were working or collaborating on a piece. Who owns the IP there? The piece, would shared ownership be a possibility, like within a family or something like that? So there's the IP question and the, I guess, ownership question.
Okay, the law merely provides for joint ownership. So, let's say there are 2 or 3 artists collaborating. I think, again, to stress the importance of written contracts, perhaps those artists among themselves have to agree that if we sell this painting, this much will go to this person, this much will go to that person, or we own the copyright to this work in these percentages. In the absence of any such agreement, it's presumed it will be equally among all 3. Did I answer your question? Do you have anything to say?
Hi. I have a question. One of the contracts that I've signed like 5 years ago with Altramondo Contemporary, the gallery in Greenville, in the contract it said there that they will not be responsible for any damages. And what happened was that after the show, 7 of the paintings were damaged, which they never paid for. All they could say was that, we'll be happy we fired the person who damaged it, as the light of here. So is that legal? That the gallery is not responsible for the damages? Ako naman, being stupid or young, I don't know which. I just signed, sure, whatever. Not thinking this, and all the other galleries have been wonderful about taking care of the art. But Altramondo damaged the pieces. 7 of them. Is that legal?
Actually, if you stipulated it in the contract, then it is actually legal. Because whatever agreement that you have, in contracts kasi, there is no limit as to what you can agree upon as long as it's not considered illegal. So it's anything under the sun as long as it's not prohibited. So when you talk about taking care of the work, as I mentioned earlier, that's why you have to be very particular as to what are the terms of these contracts whenever you consign a work. Because again, when you consign a work, ownership does not transfer to them. So
So the liability of loss is also not, I mean, it's not, it doesn't go to them, it's your property. So when you lose it or it gets damaged, then you will be the one who will suffer the damage. So one of the ways that you protect yourself from this is that when you enter into consignment agreements with the dealers or like the galleries, be very specific about who will take care of it, particularly that's again, one of the problems here in the Philippines is that we don't have art insurance per se, like per item. No, it's usually basically the entire place, and they cover the artworks that. It just so happens that they also cover the artworks that are within that building. But it's a property insurance, not an art insurance. So. For artists, it is important that for you to be protected, you need to discuss the procedure on how they will transport, how will they package. These are the things that you must discuss with the galleries in order for you to be able to be protected. And at the same time, once you've discussed all these terms, you have to put it in writing so that they will be bound by it.
There's also the artist right I read about is involved an Australian artist. Basically, she had a horrible relationship with her galleries, and I know that artists we have a right to disown an artwork. Meaning, for instance, if you were H.R. H.R. Ocampo would say that no, even though he made the artwork, he can disown it. It's supposed to be an artist's right that I've read about, and it's a right that I'm curious about using. I wonder if you've ever encountered such a case in the Philippines. Basically, I want to use it so that para mawala ng value yung work, so that the person who double crossed me can't sell it for profit. That's what I am thinking.
I think what you're referring to is the moral right of the creator or the artist to restrain the use of his name in a work which he did not create.
Oh, no. I mean the right to disown. Yes.
His own work.
I don't know, but maybe internationally it does, but maybe in the Philippines.
I have not encountered that. Perhaps, I have not encountered that. Yeah, and it's really his work, but he is disowning it.
Yes. In the one I read, in the article that I read, it's called Art Scene. It was basically an Australian artist who, having had a bad relationship with galleries, disowned the artwork, claiming that she mentioned that the edges don't work perfect or pristine anymore, and so it no longer represents her vision. It is no longer her artwork. Therefore, she disowns the artwork.
I think that falls under one of the four moral rights. Yes.
Wait, that's
I think because one of the rights under moral rights is right to attribution, meaning to be recognized for the work that you did, no? And you also have the right of integrity, meaning the work dapat bawag bababuyin or magsisirain. Now, if it was destroyed or some of the parts has been altered, then he can now denounce it because because of the fact that it was already the integrity of the work has already been violated. Therefore, he can now claim that it was no longer his work.
Thank you very much. Just one last question. This was about taxation. Realistically speaking, at what income level per annum might it be a very smart and, a smart decision to register with the DIR? Because I'm thinking kasi like kunyari 400,000, di naman papansin. Nagpagod ka lang.
Under the law, if your income is more than 250,000, you're liable to pay tax.
Yes, but so you would recommend?
I would recommend you pay your tax if your income is already subject to tax.
What does the law say on cultural appropriation for like iconic imagery throughout history? history, if you want to incorporate it into your work as a metaphor, just to symbolize something, in how many years, yeah, what are the rules of that?
What do you mean exactly by cultural
Let's say, you want
appropriation?
to use McDonald's, yung logo, to symbolize, let's say, capitalism, to like jab, diba? Or to question or to be critical of certain themes. Or you want to use a popular scene in a iconic movie to symbolize something related to the context of your work as an artist. Usually it's critique.
That would fall under fair use principles as long as you are using it legitimately to make a comment about the current situation or to parody or to make fun of something. You may legitimately copy certain things that otherwise would be protected by copyright. With respect to logos and trademarks, that
Here's very young, but internationally there have been cases when artists have been sued, or it's not just necessarily to boost your marketing or yung clout mo in the scene, but it's to represent a certain context or theme. So those lines are very blurred. So I was wondering, how do artists protect themselves when expressing? It's not copying the style, it's using it as a symbol. Like, yun nga,
Actually, in other countries, the use of the trademarks is not really put into question as much because, first of all, the trademark
by your using it in your other work. Those are four factors. They're not by all means exclusive. Other factors may come into play. But think long and hard when you are appropriating things. If you can justify it, that's the reason why there is this concept.
so how about if it comes from your end naman na you see someone who, you're not an icon or whatever, but you see that their work's extremely similar to yours and you know that they're like stealing your ideas. Because no offense, but I've seen really popular artists here and I've seen the international artists whom they copy from. It's just the market here is not aware that they're famous here. So like, of course you
Can
lose.
you name names?
No.
So we will avoid
I'm
those artists.
only mean. I don't want to cause trouble. I know.
Name one or two.
No. Kawawa naman sila nagsusunod sa fair.
So, what is your point? Are you outraged
Yung
by this?
parang how do you... Well, of course, personally, I lose respect for those artists
Right.
because why are you... Diba? And I don't know, it's just really sad that we have... I mean, in the film industry here is the same way. They copy concepts. How's that? What if...
Well, yeah, concepts.
Diba?
They're free to be copied.
Yeah, like Century Tuna, for example, here, they copied Vogue. Parang yung segment ng Vogue na question. 21 questions, I think. But like, it was the exact same, the way they executed. But how will Vogue, let's say if they wanted to go after Century Tuna, how do they prove na you copied our concept based on the look of the execution and...
actually concepts, as attorney Lisa already discussed, ideas and concepts are not covered by copyright. It is the actual expression of that idea that should be copied for you to be able to violate these rights.
Ito, example lang. Two lovers who are belonging to different clans. They fight it out, and then in the end, one of the lovers dies. What's that? Romeo and Juliet. Ano pa? What iteration have you seen that in?
I know, I'm talking about the actual like execution.
The actual execution of
Yeah,
it.
yung the tone. Video is hard eh, but like you get, it's so obvious na the parallel.
Side
You
by
can
side.
see, yeah, na they copied it. But
Yes.
mas ano pa yun murky kasi video. But even for like paintings or artwork style, na you see that they took specific, and it's not nga for the use of commentary, it's purely out of style.
I have seen those paintings that you're referring to, and some of them are copying national artists. The style is very blatant, and if you take a second, if you look at it, hey, this is Hyugo, for example, but the style is done that way, but it's by this new artist, right? I think the case could be made that that is already copyright infringement. But then the thing is about intellectual property rights is these are private rights. They must be asserted by the person involved. So if the person involved or his estate are not interested in filing cases, then these things will go unchecked.
Just might be a waste of time for the other artists.
Well, you can also look at it from the point of view that imitation is the sincerest form of flattery.
Last question, for taxes, since our practice is so erratic and inconsistent, and what if you decide to rest for a year, not do a show, the next year you do 10 shows, how do you navigate that in terms of making reports? Or what if you have 10 shows, you only sold one piece in a year? And then does it apply like rebates, right? When you account for all the expenses like materials and yun rin, sobrang murky, like you go to a place for inspiration, like how do you, yeah.
Actually, you just write it down, and then basically now you really have to get an accountant. So the accountant will be the one doing it for you. Once you register with the BIR, there is a monthly filing. And the problem there as artists, it's not always that you earn monthly. Sometimes there's an income in January, and your next income will come in May. The problem there, you're required to file monthly. That's why I only suggest that you get an accountant, because if you do the accountant, we do the filing for you. Now, with regard to your expenses, let's say when to this particular place, you get inspiration for you to do your artwork, you can expense those costs. So when you make painting and then there are expenses incurred, you can write it down into your accountant. Then in your accountant, you dock it as a legitimate expense in creating your artwork.
Just an addition to that. The reason why we always refer to our accountants, because even us lawyers who knows tax, we usually rely on them to file these things. Because the tendency is, when you're doing work, like for example, you're an artist, you paint. Us lawyers, we sometimes go to court, or sometimes you go to meetings, then you get lost in what you do. So the tendency is you forget these things. That's why it's important that you really get accountants for you to be able to keep track of all these things.
May I ask about the 5% intellectual property for resale? It's our usual question among us artists. So there are three topics I'd like to cover about the IP. Like number one, for an individual artist, I remember asking a gallerist about it, if they give 5% IP to the resales that they make to the different artists that they sell. And she said that we have to register in the National Museum our artworks so that they would be recognized for that 5% IP. Which, when I asked about it from other people, it's not really like that. And then number two, for a deceased artist, that the 50 years has not yet been expired, can the family ask for the 5% IP of the resales of, for example, their father's artwork, like from an auction, because that's easy to know that they made the resale because that's very public. So can the family write to the auction house if they can get 5% IP? And then number three, is IP waivable? Like if a collector asks an artist, can you waive that 5% IP for me forever? Is that waivable? Kasi I believe an artist's right for the IP should be forever. So, sorry na.
Your first question is with regard to the IP, the 5%. You actually call that during this. Okay. During this, it's actually a French word, so during this. Okay. That's actually 5% of every sale, the subsequent sale. So the first sale from the artist to the leader or the buyer, wala pa siya. But as for the subsequent sales, every subsequent sale should be covered by that provision, which requires 5% of the gross selling price. Okay? Well now, while that's written in our laws, the problem again with intellectual property is enforcement. So while it's a very noble provision, again, it's so hard to keep track since the art industry is not regulated, it's unregulated. There's no body that can keep track of the number of transactions that the art piece will be involved. So that's one of the questions now as to how to enforce that.
Regarding the need to register with the National Library, that's BS. There is no need to register.
Or even to the National Museum,
The
right?
National Museum. What did I say?
Library. Library.
National Museum, I don't. No. It's just in the law that says you are entitled to 5% for every subsequent sale.
Unregistered or not.
So that might be a policy of that gallery, but nowhere in the law can you find that prior registration is required for you to obtain that 5%. And yes, I agree that in auction, it is easier to make a demand because at least we know that this artwork was sold at auction for this price. So a demand letter could be made both to the auction house and or the consigner of the art gallery, the consigner of the artwork, the person who consigned the work, the auction, that the 5% must be paid to the estate of the artist or to the artist if he's still alive. So, lastly, is it waivable? That follow-up right, I don't think there's a provision that it is not waivable. So, like it is an economic right. So I think it can be waived in writing, but it must be in writing. But I don't think there are any artists alive who would like to waive that right. Yeah, unless they need a gallery more, and the gallery needs them.
As for the deceased artist question, what about the family estate? I mean, do you just call it an estate? Do you register that there is such an estate?
The heirs would have to be represented, so they can appoint a lawyer to be their administrator or attorney in fact. They are designating this person to collect 5% due to the deceased person's.
And upon finding a lawyer, it should be a lawyer that specializes on IP, like you, or?
Well, it could be, but if this case would go to litigation, I would prefer that you hire somebody who would take the case to court and be more tenacious in getting what is due for his client. Because if indeed that 5% is paid on 100 million peso painting or 10 million peso painting, it's quite substantial. So you can negotiate with that lawyer that any amount that is recovered, you will recover a percentage of that.
Thank you.
Hello, may I clarify if what you said earlier about the 250,000 pesos in tax?
Because under the trade law, the first 250,000 is not subject to tax.
The first one?
Yes.
But let's say we have an artist who
is just starting out, like just freshly graduated out of college, art school, and they want to do art as a full-time job in their own homes. Would they have to mention in their application for TIN that they will be working from their own homes and that they're, because I'm also concerned about, because you also mentioned an accountant, and a lot of these people like my age don't really have that much money to afford an accountant even, or even a lawyer for that matter, in case of any legalities. So my concern is especially, like how, in your point of view, especially considering that what Attorney said earlier, that the art industry is very fast-paced now, moving forward very fast, and to be fair, the art industry is very competent, especially today. Shucks, what was my question? Sorry. From your point of view, what would the ideal startup be for an artist if they want to pursue it as a full-time job for themselves? If they don't have any people to, or have any clients who are commissioning them yet, what is the ideal setting in your opinion to start?
Can I try to answer this? But you validate it, Robin. You validate this. I think under the law, if your gross sales do not exceed 3 million in a year, you can have an optional, you can pay a standard 8% over and above 250,000. The first 250, mali. Tama, ikaw na naman sumunod.
The 3 million is for the VAT. So that it's not subject to VAT.
How about income?
For income tax, you're subject to the graduated rate. Ay, 8%. It's 250, it's not taxable. It's only
Yeah,
about
so except yung first 250 mo, kunyari below 3 million ka, yung gross sales mo. Ito lang, kung hindi sumobra ng 3 million in 1 year, deduct mo yung 250,000, tapos yung difference, get that 8% on that, and that's the amount of income tax you will pay. Tama ba?
So this is within a year, yearly 250,000 in a year. Is it?
Yeah, if it's 250,000 in a year, except you don't have to pay taxes. If it's below 3 million in a year, let's say below 3 million, parang micro-enterprise kayo yung pagkalag ko. So, let's say 3 million yung sales mo, i-declare mo yan, 3 million, minus 250,000, and then tama ba?
It's like this. In first 250, it's not really taxable. In excess, there's a tax. But it's graduated. Yung 3 million, kasi diba when you buy a thing, there's the income tax that you pay, and there's the VAT. But 3 million or less in gross mo, that's not subject to VAT. Wala kang VAT. But you're subject to income tax.
Can you just take 8% of the excess of 250,000? So let's say 2.5 M minus 250,000, 2.25 M, tapos 8%.
No, the government will do it at the gross. You don't have to do it now. Yung sabi lang nila is the first 250 is not taxable, but yung excess, matatax ka ng 8%.
8%.
Depende on how much.
Yeah, if you don't go beyond 3 million.
8%, yes.
Tama. So I think it's 3 million. If you're not declaring income more than 3 million, you can opt for this 8% deduction, 8% payment of tax. And so that's what you're going to pay for the entire year as income tax. And you'll be exempt from VAT kasi below 3 million. So yung situation niya, student eh. So hindi pa naman siguro ganun kalaki yung income niya from the sale of his or her paintings or whatever.
The problem there kasi is,
Actually, she mentioned that she's an employee.
if you're an employee, the one who will pay for your taxes is your employer. Because as an employee, you're given your compensation. Misweldo ka. So you have your salary.
I'm still a student. I was just saying, from the perspective of the artist itself. Because I'm also concerned about, because you also mentioned that we need to pay taxes because of the infrastructure that the government is offering us or giving us, providing us. So my concern is also that what is the artist getting in return if they're barely earning as much as they should be, as expected by the government?
You're just taxed based on how much you earn.
Just how much?
As per the setup, we always advise the people, the art community actually, that as early as the beginning, you should already be registered. Number one, of course, if you're registered, you have the ability to issue receipts, and that's already a big barrier. If you are, corporate clients will never entertain you if you will not issue receipts. Especially if your the artworks that you're selling are substantial. Why? Because they will not be able to use this in their books as deductions. So that alone should already trigger, or should already mandate you to already register with the DIR, so that you will not be hindered by this requirement of corporate clients. And then second of all, I know artists do not require offices, formal offices, but at least you have a studio. You can use your house as a studio. Because most often than not, people actually look for a certain sense of permanency. Na hindi kayo fly by night. Mawawala lang after people pay you. So you should always have at least a semblance of an office, that you are registered, because these are badges of authenticity or integrity in your work. So that's why we encourage that all of you really register your business or your profession.
I have two questions. First one, regarding idea expression dichotomy. I used to work as a concept developer for a television network, and part of our work was to develop concepts and then try them to actual shows. That particular show was already approved by management, so it's already done for production, but it was shelved 5 years ago. Now, the question is, I wasn't a regular employee because part of my job before was talent as a concept developer. The question is, should it be, do I have rights with regards to that as the original head of the concept development for that particular show, or can I be aggressive and just go to the network and remind them that no hard feelings with the network, it's just that I just want to know my options. I can go back to writing television. So I want to know if should it be, I haven't seen it, hindi ko siya pinapalabas sa TV, so I know it's not yet airing. So can I go to the television network and remind them that there's this concept, if you want to finally invest on it, then I can write for it.
I'm not quite clear how much of the concept has been developed.
It's already, the pilot episode has already been written,
Okay.
and it's already complete for one season, so it's 12 weeks.
Okay. So,
Yeah, okay. So it's already, the last step for that is actually looking for a third party, it's a third party client, to work with the network to produce it. So that's the only thing that's stopping it. So assuming if it will push through, what
is your intention now?
I just want to know the options that I have. I know that the network owns the copyright for this, right?
For the episodes, the pilot
Yes,
episodes, and the treatment.
The seeding, all Latin sequence
Sequence
until the 12th episode, so until the whole season. Just
In other words,
Sorry.
do you want them to air it or to?
I just want to know if should there, because the process is sometimes there are new concepts and there are very old concepts, and maybe in the coming months you'll see very old concepts coming to life. So we never know. Just want to know my options. Like, for example, should they air it like in 3 months? So I want to know.
There is no requirement for them to air it. There is no requirement for them to show it.
No.
It's just that they paid you a certain amount to develop the concept.
No, it was part of my job before. So
Yeah.
So
It's part of your job.
I was paid monthly for that.
Okay.
Just to develop concepts.
So I think they would own the story treatment and the copyrights to that because there was an employer-employee relationship,
But can I present myself and then
and then
I just want to know if ever they aired it, can I be credited as the concept head of concept?
it depends on your contract of employment. What does it say? But if you do it with the regular course of your duties, that's
As a
expected.
talent,
Then I don't see how you could force them to be recognized as the creator because effectively you transfer the copyright to them.
Yes.
Yeah, and it's done in the course of your duties, right?
The next question is regarding art leadership. So with regards to the artist, is there any like a general rule regarding transparency? Like for example, if a certain painting was if for example the painting cost 100,000 and as a dealer I was able to sell it for 150,000. Number one, should the artist do I have to tell the artist that I was able to sell it for 250,000? Or
As I mentioned earlier,
50%?
as I mentioned earlier, usually the dealer has a fiduciary relationship, meaning he should put the interests of the artist before himself. So the fact that you already concealed the true amount of the sale, you already violated that relationship. So there's already a violation there. Okay? Because number one, you are supposed to reveal how much, even to who you sold it to. You have to reveal it to the artist. Okay? So if he does that, there's already deceit. Usually that will already result in a criminal case if you do it.
And just last note, do you have advice for budding dealers with regards to being legally as an art dealer? Do you have any advice for budding art dealers? Starting, yes. Because I think you mentioned earlier that one of the criteria, you need to have a physical and actual location for a gallery to be able to deal art.
Well, as much as possible, especially with the movement now that everything's on the internet. Again, there should be at least a semblance. You don't have to have it in a very posh location because that's the beauty of the internet. People will be able to see the works that you have, and in fact, you are no longer limited by space. Because most galleries, that's one of the problems. As much as they want to showcase all these works that they only have limited wall space for them to put those artworks. Now with the internet, at least you will be able to show all these works that you have, but without the limited space. Unfortunately, it is very dangerous to buy paintings in the internet. You need to look at it physically. You need to check it physically, particularly as to the state of it, the condition that it is in. That's why you need at least a space you still need a space for display these works. But again, if you're a starting gallery, number one, you have to be very careful with how you deal with artists. Because at the beginning, most probably, you're going to be dealing with startup artists as well. Now, the problem I mean, in my experience, the problems that we encounter with artists is that they seldom deliver the art on time. That's really a big problem for us. You know, I hope the artists are here, the dealers are here, and I hope you understand how the business works. Because the dealers are not necessarily artists. And they deal with people who sometimes don't really understand the creation process of artworks. So for them, it's a straight transaction. I'm gonna buy an artwork from this certain artist. I'm gonna get it on this specific time. And now you're this dealer who's dealing with an artist who's apparently not even lifting a finger to start the work. Diba? And then the day comes when the dealer's client now or the buyer now is collecting the work, and yet your artist hasn't even started it. Diba? And that's actually the reality that happens all the time. So for you, you have to be very careful with how you manage your artist. You have to make sure that the work is being done, because at the end of the day, it's not his reputation that he's being hit, it's your reputation that is being hit. So, as a suggestion, that is the first step into building or establishing yourself being a good leader. Is for you to be able to manage your artist properly, so that you will be able to deliver the works on time.